the limits are on the government's police power and what that does to individual liberty. At PLF, though, our focus is on the future and how we can unleash the individual to rebuild America once we do open back up. We're looking over the horizon to the fundamental relationship between the individual and the state. To reshape that relationship, we believe you need to apply a coherent and long-term strategy. There are undoubtedly little fires everywhere. Some we're looking to put out, some others are putting out, some will die out on their own, and still others exist with no end in sight or viable path to litigation victory. We've seen these injustices and are sympathetic to the impulse to do something in the near term. We talk more about that time frame in an FAQ section on our website at pacificlegal.org/COVID. But what we ultimately want to do is take away government's gasoline and matches so it can't respond, whether in a crisis or otherwise, in a way that's antithetical to our individual liberty. We've identified several areas where we'll be focusing our activity, at least initially, and where we think we can best apply our expertise and experience. In 4+ decades in business, if they've taught us anything, it's that the price of liberty is eternal vigilance. At PLF, we're culturally optimistic. And as I wrote to many of you in March who were at this town hall, we're optimistic about our chances. We know that success on our end will equal success for the nation. We're also confident. I actually take comfort in the fact that Americans are those that question government policy, that Americans don't take no for an answer, that Americans, most importantly, want to make decisions based on what's best for them and their families. We all yearn to be free, and the pushback that we're seeing against the stay-at-home orders, in particular around the country, show that there's a unique American spirit that persists and will prevail. Before we get to the substance of today's program, one further note, which you saw at the slide at the beginning, and that's we're going to be taking questions after the presentations. In order to pose any questions, please use the chat function on Zoom. We'll also consolidate questions that you may have provided to us when you registered for this program in the first place. We have 3 stars in the PLF constellation that we'll talk to you today. The first is Anastasia Bowden, who also is here under lockdown by Governor Newsom. Anastasia is a senior attorney here at PLF, and she works on our Economic Liberty Project. So Anastasia, take it away, please.
Hi, everyone. Thanks for joining us today. In preparing for this event, I've been thinking about how my family has been asking me, and in particular, my husband, how I'm staying so calm, because for any of those of you who know me, I'm not a particularly laid back person, and yet I found it fairly easy to remain optimistic to the apparent shock of my friends and family. And I think that's because working with entrepreneurs all of the time, I have an unflagging faith in the capacity of human ingenuity. We will be able to innovate our way out of this health and economic crisis with one caveat, and that's that we get unnecessary red tape out of the way. So I wanted to offer some ways that we can unleash entrepreneurs to both help solve the health crisis and the economic crisis. We've heard a lot about flattening the curve. We have to flatten the curve so that we don't overwhelm the capacity of our healthcare system. But that's just one part of the necessary approach. We need to think about why is supply so low in the first place? Why do we have fewer hospital beds per capita than even Italy? And also, why are we treating capacity like it's something that's fixed and that flattening is the only option? There are ways that we can boost the supply of medical services and equipment through healthcare entrepreneurship. So I have 3 specific recommendations for healthcare entrepreneurs. And the overall theme for all of them is let qualified people do their jobs. And that sounds obvious, but there are myriad regulations in the way that prevent perfectly qualified people from working in the healthcare space. So the first policy recommendation I have would be to allow licensure reciprocity across state lines. There is no reason why, if there is a bubble, let's say next door in Oregon or in Nevada or whatever states are next to you, why licensed medical personnel cannot just simply cross the state border and provide potentially life-saving services there. And the same goes for restrictions that generally prevent people from working across state lines in other ways. Telemedicine comes to mind. Telemedicine is actually banned in some states. And we've seen emergency measures come through to relax some of those restrictions. We know that, for instance, Medicare and Medicaid have liberalized their reimbursement rules for telemedicine to make that an option for people who don't want to go to the doctor's office right now and want to receive medical services in other ways. And we've seen, for instance, Governor Cuomo recognize licenses from other states as an emergency measure. But these are things that we should be thinking about even after the pandemic passes. These are arbitrary barriers to perfectly qualified people doing their jobs. Arizona recently became the first state in the nation to actually allow reciprocity across state lines under certain circumstances. And that's, I think, a good policy moving forward for healthcare workers. The second recommendation has to do with scope of practice laws. So these are laws that require licensure as a doctor for services that really could be performed by a nurse, or that require licensure as a nurse for services that could be provided by a physician assistant, and so on. We're hearing stories of nurses and physician assistants who have served in the Army, who spent years in the emergency room, yet they're being denied the ability to help out with this crisis. Particularly, there's this story of a woman in Florida who is a physician assistant who spent years in the emergency room. But in Florida, you have to work under one doctor, and you can only do things, if you're a physician assistant, that doctor delegates to you within his scope of care. And so for this physician assistant, she recently switched over to cardiology, which means that if her own ER became overwhelmed with coronavirus cases, she cannot go down there and help out. She's prohibited by law because she must stick to cardiology, and that's a shame given her expertise in that area. So we need loosening of restrictions on that front as well. A similar issue has to do with pharmacists. Pharmacists are perfectly qualified to do things like refill prescriptions without doctor authorization, yet in some states they're prohibited from doing so. That's especially important now when people don't want to go to the doctor's office to get a refill. The doctor's office is, full of exposure. And so they should be able to get immediate emergency refills from pharmacists. And if states loosen up their restrictions, they would be able to do that. And the last policy recommendation has to do with something that's particularly near and dear to PLF's heart and my heart, and that is certificate of need laws, which require you to prove that your business is needed before starting up or expanding. In 36 states, you have to get a certificate of need before building new facilities. So you can think of things like birthing centers or surgical centers, or purchasing new equipment like an ambulance in some cases, or even hospital beds. Just for a hospital to add simple hospital beds to expand capacity in that way, they have to go through a very onerous process and prove that that's needed. This process is separate from satisfying any health or safety criteria. It's solely devoted to proving that you're needed. And how does the government make that decision? Well, it invites the existing certificate holders to show up at a hearing and testify whether they think that new products or services are needed. And of course, evidence from PLF lawsuits reveals that applications are almost always protested, and protested applications are denied because the government just defers to the existing certificate holders in making this determination. These laws do not protect health or safety. They are not devoted to ensuring that people are qualified to do their job. They stand as a barrier to legitimate competition and healthcare entrepreneurship. We see that in these cases, the government is usually relying on some sort of economic argument, like that they need to ensure that there's adequate supply. They know better than the market participants themselves, the entrepreneurs, whether there's new services that are needed. But basic economics would predict how these laws play out, and that is that they do not lower prices or ensure adequate supply. They drive up prices and they create shortages. So research from the Mercatus Center, for example, shows that certificate of need states have about 131 fewer hospital beds per every 100 100,000 residents compared to non-certificate of need states. And this is exactly why the federal government, which used to incentivize states to have this silly policy on the books by offering subsidies and such, has actually abandoned those subsidies entirely. And both the Department of Justice and the Federal Trade Commission have urged states to repeal these laws. But these laws stay on the books because there are very powerful interest groups that like them because they protect these groups from competition. These laws harm entrepreneurs and consumers. We have a lawsuit here at PLF on behalf of a small ambulance business in Ohio. It's a family-run business, and that business simply wants to provide medical transportation 1 mile away in Kentucky. But when they applied for a certificate of need there, they were protested, and Kentucky ultimately told them that their business wasn't needed in Kentucky. And that's a shame for our client who is providing jobs for his community and his kids. But it's also a shame for those people in Kentucky who cannot simply jump in an Uber or a taxi. They need an ambulance to get around, and they're being denied this vital service for purely anti-competitive reasons. So these laws are pernicious in any case, but it's basically the opposite of what you want during the middle of a pandemic. You want healthcare providers to be able to be nimble and flexible and to respond to changing demand quickly. And that's why we're seeing many governors suspend these laws. At least 22 states have suspended their certificate of need laws. PLF has called on the remaining states in letters to the governor to suspend these laws, at least for now, and ultimately to get these laws off the books indefinitely so that we are not ever again in the future caught with our hands tied behind our back and healthcare entrepreneurs being held back from responding to something like this pandemic. Outside of healthcare, I think we have to simply allow entrepreneurs to do what they do best, which is to find creative ways to get back on their feet by catering to new demands. So occupational licensure, of course, this has become a hot topic that nearly a third of Americans are locked out of work by onerous licensing laws. The types of jobs that require a license nowadays is no longer just doctors or lawyers or things that we traditionally think of as requiring a license, but physical trainers, masseuses, makeup artists, hair shampooers.
And they had power given unto them.
I think
that they could not be confined in dungeons. Neither was it possible.
Someone needs to mute their microphone. But in any event, we see all of these occupations. To list some more: unarmed security guards, upholsterers. All of these jobs now require not just registration or a mandatory bond or some level of training or a certification, but full-blown licensure, which is the most onerous form of regulation. And we're shutting people out of jobs when study after study shows that these laws do not improve outcomes. They simply stand as an anti-competitive barrier to entering the trade. There's no reason why it should take 1,600 hours in the state of California to get a license to cut hair or even just to shampoo hair. These laws never made sense before the pandemic, but I think before the pandemic, politicians could get away with it. But now we are in an economic crisis and we really need to do away with arbitrary barriers to earning a living. And on that note, CON laws, certificate of need laws, actually also apply outside of the medical industry to things like transportation, so moving companies, shuttle businesses. PLF has brought several lawsuits in this area to get rid of CON laws outside of the healthcare context as well, and that's an area where regulation would really free up people to entry-level jobs. The second recommendation would be to get rid of one-size-fits-all regulations that prevent people from flexible work arrangements. So AB5 in California is a great example. Many states are considering mimicking AB5, and that's our law that recently expanded the definition, I should say it reduced the ability of businesses to classify people as independent contractors. And this was a paternalistic and condescending law to begin with. It assumed that people couldn't take care of themselves, so they were somehow being exploited into these jobs when they didn't want. But in reality, people desired these flexible work arrangements because they want to engage in jobs that suit their lifestyle. Maybe they want to look after their kids part-time, or they want to pursue multiple jobs or side jobs or passion projects. And ultimately, AB5 was aimed at converting these jobs from independent contracting to full-time jobs with full-blown benefits. But what we saw was, rather than that, these jobs just simply disappeared. And that's a real shame, where right now people could use those jobs that are part-time so that they could take care of their kids while their kids are home, or study for school, or pursue whatever their interest is. And now those jobs have simply gone away. And we need to let people find ways of working that suit them and get rid of these one-size-fits-all regulations that only suit bureaucrats' preferences, but not the preferences of individuals. And lastly, just briefly, many places ban or severely restrict home-based businesses. I think the pandemic has made clear that many people can work from home, and there's no reason why localities should be making it illegal to even, let's say, sell arts and crafts on Etsy, or once we're open up, here in Sacramento, we're still at stay-at-home orders, but eventually when we're able to have people to our homes, why you can't just have one person over for tutoring or for music lessons or that sort of thing. These are good ways for people to earn an extra income, and they're being prevented not because they're unsafe, but because of onerous regulation. So I guess the theme is let qualified people work, allow people to find creative ways to pick themselves up by the bootstraps. And I think that will be a great way to not only solving the health crisis, but also to getting ourselves out of this economic crisis, and we will find our way out.
Thanks, Anastasia. Next, we're going to go up the Pacific Coast to Washington, to Bainbridge Island, and I'm going to turn it over to Senior Attorney Brian Hodges. Brian runs our initiative to legalize the production of housing and is going to talk a little bit more about property rights.
Thank you. In order for the nation's COVID-19 recovery to be sustainable, we'll need to defend and promote private property rights. Indeed, the pandemic has shown now more than ever what we've been saying for decades here at PLF. Secure property rights are essential to health, safety, and economic well-being. Yet much of the government's response to the COVID-19 outbreak has been the exact opposite, has been to uproot security and private property, particularly in areas like Seattle or California, where we've heard proposals to do such things as impose rent moratoria, to forgive people for non-payment of rent, to suspend residential construction. All of these are devastating to our investments in private property. But the real threat will come when America reopens, because unfortunately, emergencies like the COVID-19 pandemic are like catnip to the socialist wing, for whom elevated levels of control has inspired dreams of converting private apartment buildings and private property into Soviet-style blocks under centralized control. Thus, going forward, we need to focus on defending and promoting property rights as a centerpiece of the COVID-19 recovery. Now, I say defend and promote as two separate subjects because really what we're dealing with are two different lines of attack on property. One is the new response that we're hearing in the news every day, and the other is an exacerbation of existing problems that have been causing the housing shortfall and housing crisis, the crisis of affordable housing across the nation. Now, defense of property rights is at the forefront of all of our minds after seeing so many anti-property owner proposals from local government. This crisis has turned into a soapbox for socialized housing advocates who want the government to take private property, to take over private property, to control the private landlord-tenant relationship. We saw this starting before the outbreak up here in Seattle, where the city council enacted ordinances that take over just about every aspect of the private landlord-tenant relationship, such as choosing something as simple as choosing a tenant. Who are you going to invite into your property to be part of your community? In Seattle, they've made that simple act unlawful. They've tried to legislate away your right to even check somebody for heinous criminal history, arsonists, murderers, people with long histories of assault are now mandated, or owners are prohibited from screening them from becoming a tenant on their property, even where they have vulnerable tenants already in place. Thankfully, though, the most extreme proposals that we are seeing appear to be dying on the vine. Santa Clara, for example, had floated a proposal that would have forgiven everybody for rents that they failed to pay during the declaration of emergency. Luckily, there was a city attorney who had read the Constitution and advised the city council that it was going to be stepping on the Fifth Amendment if it just by act of fiat extinguished this obligation to pay rent in order to live on the property. Yeah, all of these actions, however, all of the proposals that we're seeing about rent moratoria and forgiving late payments or reducing rent, interfering with the landlord-tenant relationship is merely treating symptoms of a much larger problem, which is the housing shortfall, which will lead to my second point about promoting property rights. So any proposal that would reduce or even forgive rent will only result in a tightening of the housing supply and will drive mom and pop and small property owners out of the rental market. They may even be driven out of their homes if they aren't able to get the rents that they need to pay their mortgage and pay for the upkeep and repair of the property. And that will in turn limit the number of people in the rental market. We would see exactly what most of these advocates don't want to see, which is a consolidation of rental market into large companies that are able to build and manage larger buildings. So in order to, we will be looking as we go forward at possible cases to defend landlord and property owners' rights against regulations like these if they are put in place. But in order to get a real solution to this housing problem, we need to build. It's as simple as that. As Anastasia brought up, this idea of capacity, of serving capacity, is an artificial idea. As is the case with economic activities, accepting the present housing capacity is really where the problem begins when we're dealing with the housing shortage. We aren't lacking in buildable property. What we're lacking is in flexible regulation. There is so much potential wealth and so much potential housing that's locked behind regulatory walls. Development is one of the most readily available and untapped resources that we have as we restart the economy. For example, one of the issues that we're looking at in the housing initiative is promoting the development of so-called accessory dwelling units, which are commonly called granny flats or in-law apartments. They're basically secondary dwellings that can be either attached to your primary structure or detached, like a secondary cottage. This, in and of itself, won't solve the housing shortage, but it will address a need, and it will have a major effect on the community if we can limit the regulatory restrictions. As we know from California and Washington, which both have very intense regulatory programs for residential development, particularly up here in Seattle, where it's estimated that 50% of the cost of a new house is directly attributable to regulations and impact fees. That if we can roll that back, if we can roll back the process, the permitting process, the approval process, in order to recognize, for example, the by right development, then we can reduce the regulatory cost and have a direct impact on the price tag of homes. Now, we've seen this in play in California, has actually been leading the way with accessory dwelling units. AB 68, which was adopted a couple of years ago by California, directed local communities to go through their development codes and liberalize them, which is a shock that we saw this start in California, but it has had great dramatic effect. If you look at communities like Santa Clara, where the average home costs $1.08 million just to get into a house, since liberalizing the ADU regulations, we've seen the number of granny flats increase from a very small number to into the hundreds the first year and into the thousands the next year, at a cost averaging $80,000 to $150,000 per unit. This is in a community where the average home price starts at over $1 million and the average apartment costs in excess of $3,000 a month. These ADUs provide affordable housing opportunities, not only for small families or single persons who are looking to get into the community, but it also provides a benefit for homes because it provides, for example, parents an opportunity to age in place rather than going to an expensive assisted living facility. It allows families to rely on each other like we haven't in a long time. In addition to liberalizing accessory dwelling unit regulations, we believe that doing so, providing an example of how relaxing regulations, recognizing by right development, perhaps pre-approving certain floor plans or development plans that you could just go into the permitting office, and if you accepted Plan A or Plan C, you just get a rubber stamp, is going to have a huge effect not only on this type of development, but will also has the potential of trickling up to other types of developments, such as single family homes. So going forward, PLF is already engaged in litigation to help defend the ADU laws in California, to fight the local governments that are putting too many impediments on this and driving up the cost of new development, and also promoting changes to regulations that are going to reduce the cost of new development, such as policing impact fees, restricting the opportunity for third-party appeals, and promoting streamlined permitting. And with that, I will turn it back to Stephen Anderson.
Thanks, Brian. We are now going to take a trip together across the country to my old home state, the Commonwealth of Virginia, and we're going to talk with Steve Simpson, who's also a senior attorney here at PLF. He is also leading our charge to undermine the superstructure that allows for the large administrative state to rule over our lives. Before I turn it over to Steve, though, I would recommend that if you have any questions for the speakers or for Steve, that you start putting them in the group chat now so we can put them together and start rapid fire questioning once Steve finishes his presentation. Steve?
Thanks a lot, Stephen, and thanks to everybody for coming. So I want to start by recalling the title of this event and talking a bit about what it means and why it's important. Rebuilding America requires freedom. So we're in a crisis, obviously. It's a health crisis, it's an economic crisis, it's a crisis of government. There's no doubt that we'll need to rebuild not just our economy. We need to do some much needed repair work to our governing institutions. But we can do that. Americans have always rebuilt after a crisis. Indeed, this country has always done much, much more than rebuilding. It's built a standard of living that is unparalleled in the world today and throughout history. To echo a phrase that some of you may remember from the last administration, we did build that. To emerge from this crisis, America needs to relearn that point, that prosperity is created by hardworking individuals, and why it happens in nations like America. Now, this gets to the twin parts of PLF's strategy. The first one might put, or I would put it this way, sue the bastards, which is to say, sue the government. But the second is educate Americans about our institutions, our legal system, our political ideals, and why we are defending the people we are defending. And both of those prongs of our strategy work together. Now, here's an observation about this crisis. Amidst all of the disagreement that we've had during this crisis, everybody agrees implicitly, at least, on one important thing. And I'll put it just like this, simply. We need more stuff. We need more hospital beds. We need more personal protective equipment. We need more medicines to treat the disease. We need a vaccine to cure it, and much, much more besides that. Now, I think everyone in this country understands this on some level, but they don't understand where all this stuff comes from and what political and legal conditions are necessary to produce it. What they don't understand is that people, individuals, entrepreneurs, the people Brian and Anastasia talked about, the people PLF represents, all built that. People don't understand that for all of that to happen, for all of that building to occur, we need freedom. We need, as Anastasia said, to let qualified people do their jobs. As I might put it, we need to get government the hell out of the way. To rebuild America after the crisis, we need to understand that we have turned a legal system whose purpose was to protect freedom into one that today, unfortunately, restricts it. So the point is that we can't just attack bad government. We also need to defend freedom and the good, innovative, hardworking individuals who use it. We need to teach people, as Brian said, that property rights secure health, safety, and well-being. These are good things, they're values. But with all of that said, we also need, frankly, to attack the government. I mean, one important part of that is the administrative state. And that's my job to help PLF attack the administrative state or roll back the administrative state. So let me say a few words about that. Now, I think when we think about the administrative state and the regulatory state during the pandemic, there's really no better example of government failure during this time than the FDA CDC testing fiasco. I'm sure you've all heard the basic facts, and PLF's Glenn Roper wrote an op-ed about it, which is on our website, and I would encourage all of you to read it. Suffice it to say that the federal government wasted probably 2 months while it prevented tests from being developed early on in the pandemic. First, the CDC tried and failed to create a test, and then the FDA didn't allow private companies or private labs to create tests or to evaluate their results. Now, many people view this as incompetence by the Trump administration or some sort of a failure of these agencies, and especially of the FDA. Now, some of that might be true, but it misses an important truth. These agencies were doing what agencies are designed to do. It is probably more accurate to say that the holdup in testing is actually a kind of, weirdly, a kind of success of the administrative state, because holding things up is what the administrative state does. The FDA's mandate is not speedy and innovative. It's, quote, safe and effective. Now, that might sound great in principle, but in practice, it means that we've created a massive bottleneck for all medical devices and drug production. Often it takes more than a decade to produce new drugs. That basic approach that bureaucrats are better poised to decide how to run the lives of many millions of individuals than those individuals themselves is central to the administrative state. And it applies across the entire admin state and the many aspects of our lives that the administrative or regulatory state controls. To put it in short, increasingly, we live in a society in which some of the most important decisions of our lives are made not by right, but by permission. We need to recognize that this is seen by supporters of the regulatory state, and indeed by many, many Americans, as a feature, not a bug. So that's the first thing we need to do to roll back the administrative state. We need people to understand that government's role is not to protect us from bad decisions or to make us safe from every risk. It's to protect our rights and to leave us free to pursue our own lives and our own happiness. And that applies even in a pandemic. The second thing we need to do is to take our Constitution and its separation of powers seriously. Now, the separation of powers is an often overlooked aspect of our Constitution, but it's one of the great innovations in political history. Separating power among three branches, giving each the ability to check the others, protects liberty and keeps government in its proper place. It also promotes the rule of law by giving us a process by which laws are created, enforced, and adjudicated. The regulatory state, by contrast, concentrates all power in agencies. Bureaucrats make law, they enforce law, and they adjudicate disputes. That isn't the rule of law. It's the rule of bureaucrats. Now, PLF's strategy in attacking the regulatory state is to support the main components of the separation of powers and to attack the legal rules that have developed over time to prop up the administrative state. So to give you a few examples of that, we are trying to reinvigorate the non-delegation doctrine, which is the simple principle that Congress must make law and cannot hand that power over to the executive branch. This is a principle that ought to be understood by the courts, but has been largely moribund and defunct over the last century when the courts have just ignored it wholesale, and that's caused enormous growth of the regulatory state. Another example is we oppose judicial deference to administrative agencies. That's one way in which the courts have ceded enormous power to agencies, essentially by handing the power over to the agencies themselves to interpret the laws and regulations that the agencies enforce, which is in effect like handing power to a prosecutor to decide whether a defendant is guilty and what laws should apply to him. It's crazy, but it's done widely, and it contributes greatly to the power of the administrative state. Another example is we support and defend the president's appointment and removal power for executive officers. This means that only officers that are appointed by the president can exercise significant power, and that those same people must be removable by the president. This principle is crucial for making agencies accountable to the people, because the president is elected and can be unelected if people are unhappy with his management of agencies. But that can't happen if he can't control the people who run those agencies. We also fight against administrative agencies that embroil individuals in endless enforcement actions. One of my favorite lines from the Declaration of Independence comes in what we often refer to as the Bill of Particulars against the King. Here's the quote, "He has erected a multitude of new offices and sent hither swarms of officers to harass our people and eat out their substance." Now that quote describes the entire administrative state, but it captures what happened to PLF clients, the Sacketts, better than anything. They've been stuck in a fight with the EPA over developing their land for well over a decade. The first part of the battle, which took years, and which PLF took to the Supreme Court, was over whether the Sacketts even had the right to sue the EPA in court. So all of these points are fundamental to PLF's strategy in fighting and rolling back the administrative state, and we will continue to put them in play during and after this pandemic. Let me just close with this thought. We know that government grows after every crisis. History proves that. The same will happen after this crisis, despite the fact that this is actually an example of government failure, not government success. We need to be prepared to fight against that growth and in favor of the people who have really made America what it is today. And that's what PLF does. Thank you.
Thank you, Anastasia, Brian, and Steve. We will now turn to questions for the remaining 19 minutes of our program, and we'll hope to get to as many of them as we can. First, let's see. I feel like a radio DJ here. Let's take Pamela's question. And Pamela's asking, and I'll direct this to Brian Hodges, who just spoke about property rights, and that is, will PLF challenge the pending Assembly Bill 828 that's in the California legislature?
Okay, well, I will start off with the good news. The good news is that it does not appear that this proposal is getting the traction it needs to become law. So there may not be a legal challenge down the road. Rest assured, if it does go forward, we will look very closely at the law. For those who aren't familiar with AB 828, it's similar to some of the proposals we've seen up here in the Seattle area. It proposes a period of time that renters can suspend rent payments and be able to pay it back to the landlord. I believe 828 says a year after the emergency is lifted that the landlord has to work out with the tenant a repayment plan. The law is so, its impact on property is apparent, but its impact on renters is so bad too, because what it's doing is telling people that they have permission not to pay, but then they're going to have to pay it back. If they can't afford their rent now, how are they going to afford 2 years worth of rent in 12 months time? It's creating a secondary crisis that's going to really exacerbate the housing crisis a year down the road. What's worse is the worst aspect of AB 828, and to me the most suspect aspect, is the part of the proposal says that for this year after the crisis, after the emergency is declared over, it proposes to go in and interfere with the landlord-tenant relationship by automatically reducing all rent obligations by 25%. If that were made into law, that would most certainly be worth investigating for its impact on existing contracts, because leases, after all, are contracts, and there's a property right in that contract, and the court can't, or the legislature can't go in and rewrite a contract that has been entered into unless they can come in and pay that 25% reduction in rent value.
Thanks, Brian. Okay, let's see. We're going to go next to anonymous Lauren McHugh, and I'll go to Anastasia about this. And that is, what can each of us actually this is from Jane Kearney, which of these, what can we do specifically to challenge and expose con laws? The opposition uses emotion in their marketing. So what efforts are being made on our side to share the impact of these cruel regulations?
Hi, that's a great question. Of course, PLF sues, and that's one weapon for getting at these con laws. But part of it is not just trying, you can't just get them overturned without also engaging in this war of ideas. Steve was talking about this. We really have to shift people's mindset. I think for a long time, these con laws, the discussions about con laws have been really academic, and people think, that's not for me to engage in. I don't know enough about it. We should just defer to the government. They know better than me. Healthcare is different. I don't know about the place of competition in healthcare. But I think by telling stories of real people who are harmed by con laws, of telling stories of our clients who, our client in Ohio who started with one ambulance just to give his kids a job and to keep them together in the same spot, and grew that business in 1 year to 7 ambulances, and is beloved by his community, and is now being shut out of the neighboring state where there's no question that he's unqualified. He's already operating. He's never had a complaint. I think by telling stories like that, it's easier to persuade people and to get them on board and to start changing people's minds about con laws and get them asking difficult questions. There's great pieces out there by Eric Boehm at Reason about a hospital that was denied the ability to open up a NICU center, and the tragic results for babies who are in need of specialty care in that area. We have to get away from the academic and purely legal arguments and also engage people with these ideas by telling the stories of the real world impact. I think that's so important. My colleague Molly Williams and I recently had a piece in the Wall Street Journal telling the story of 3 entrepreneurs, 3 ambulance businesses who wanted to start up and were denied. And now look, we're in the middle of a pandemic, and these 3 separate businesses, each with very, heart-wrenching stories about the desire to provide these services. I think that goes a long way in just changing people's mindset about these laws and combating the hospitals who come at you and say, well, people's lives are on the line. Don't engage. People's lives are on the line. We say, no, exactly. People's lives are on the line. So we need to talk about this. And if people's lives are on the lines, that's exactly when competition is most important, because competition is the driving force of improvements in quality and bringing down prices and improving access. So I think just engaging the public is so important, in addition to suing and putting out research. Mercatus has been great on that. We have at PLF, we have an upcoming research paper coming out to actually show people the facts about these laws. So it's really a 3-pronged approach. It's suing, it's research to get the facts out there, and it's telling these stories to change people's mindset about blindly deferring to government regulation.
Okay, thanks, Anastasia. I'm going to do an anonymous question now. And this one I'll send over to Steve Simpson. What's the best legal basis for challenging the shelter-in-place orders? The police power is broad during a pandemic, but these orders can't go on in perpetuity. If you want to, as part of that second part, Steve, maybe talk a little bit more about the police power and just how relatively ill-defined it has been over our history.
Yeah. Sorry, can you hear me okay?
Yes, we can hear you.
Okay, good. Sorry. It seemed like my thing was muted. But anyway, yeah, that's a great question. It's a really hard question. So let me start with the point, Stephen, that you made, which is the breadth of the police power, because we're hearing all over the place today from legal scholars, from lawyers, from thinkers, from government officials, that the police power is enormously broad. And there's something to that. I mean, it is definitely true that the police power, especially in an emergency, is very broad. And for those who don't know, the police power is basically just the state's power to protect the health and safety and welfare of its citizens. The state governments have broad powers. The federal government has narrow and enumerated powers. And this has been around, this idea has been around since literally the founding, and in fact, before the founding. But one thing we have to understand about the police power, and I think it's a better way to think about it, is yes, it's broad, but mostly what it is undefined. And it is a very traditionally based power. That is, it has a lot of historical roots. It doesn't have a whole lot other than particular aspects of the Constitution, let's say the Bill of Rights, that restricts the police power naturally, whether it's under the federal Constitution or the state constitutions. It's not entirely clear how far the police power reaches. So one of the things that we have to do, I think, in pushing back against these lockdown orders is to make the argument in the court of public opinion that the police power is very undefined, and it's really broad, and we really need to define it. That is, state legislatures could define the police power. They could restrict the police power. They could issue laws and laws that define what the proper role of a state government is in an emergency. And I think going forward, given this experience, given the fact that we haven't experienced a pandemic or the exercise of police powers really in, I think, all of American history to this extent, to the extent that we're seeing it today, now and after this emergency would be a great time to convince our state and local governments to actually define what the reach of the police power should be. Now, to answer the first part of the question, what are the best ways to challenge this? It's a really hard question, because precisely that over long periods of time, courts have very much deferred to governments in defining both the extent of the police power, and especially during emergencies. I mean, there are constitutional arguments that one can make. One can make an argument that that these lockdown orders at a certain point violate or deprive one of life, liberty, or property without due process of law. Let me just offer this one thought because I could go on for too long on this point. I think the best way to approach the lockdown orders and challenging them is to both challenge the breadth and length of them. In other words, they were supposed to be temporary, and now you're changing the justification for them. There's a sense in which we're moving the goalposts, and that's an arbitrary kind of government action. And the other is that that oftentimes, and I think Brian was talking about this with respect to the various laws suspending evictions, the police power in the emergency is being used as a pretext to achieve other goals, the kind of things that have been on the shelf for a while that bureaucrats and state officials have been wanting to propose for many years, and now they're taking this opportunity to do that. Those are good challenges to these lockdown orders because they show the limits of appropriate government action and the extent to which that action can be arbitrary. And PLF is looking into a lot of those challenges. So we'll keep looking at it, and we'll be doing what we can in the future as this crisis unfolds.
Okay, I'm going to go to Brian for Pagona's question, and that is, what are ways that individuals can help implement this plan in their areas?
Yeah, well, there's a couple of really clear solutions that we hope we've made portable enough that you and your friends can bring to your communities to help advance these ideas that we were talking about. First, in the chat bar, we put a link to a piece that we published called PLF's Roadmap to Recovery. That provides a general outline of the issues that we were talking about today that could be shared with people in your community and local governments to help start this conversation. In addition, PLF attorneys are also working with some of our partners across the nation to publish a toolkit for recovery that goes into much more depth on these topics. And we'll be partnering with other think tanks and other similar-minded organizations that will provide a much more detailed step-by-step process that local governments can take to take these pro-freedom steps towards recovery. And if you check on PLF's website, we will be promoting the toolkit when it gets published shortly.
Thanks, Brian. I'm going to go back to Steve for a question that is a bit related to the one that you just answered regarding the police power, and that is, do store owners have the right to require customers to wear masks before entering their stores?
Sure. I think that one is actually pretty easy because store owners, yes is the answer. And the reason is that store owners own the store. In other words, that's an exercise of the right to private property, among other rights. And in fact, the way I would put it is even stronger than that. It's not only that they have the right to do so, part of the solution to a pandemic like this is that we should be relying on individuals, meaning individuals just living in society and individual businesses, to, I think, provide the bulk of the response to the pandemic. That is, not only to innovate and do things like create medicines, vaccines, et cetera, the medical care that we need, but individuals and business owners need to be coming up with solutions to or ways of implementing social distancing. That is, if we take social distancing seriously, and I do, it seems eminently reasonable. One of the problems with the lockdowns is that it takes both the costs and the benefits out of the hands of the people who experience them, out of the hands of normal citizens. And it basically puts that responsibility on government to try to divine top-down solutions. What you need to happen instead is that individuals need to be thinking about how to solve these problems. Businesses need to be thinking about how to do it. If you go out now, you can actually see examples of businesses doing that. We need more of that. We need more decentralization and less centralization. So store owners requiring people to wear masks, I mean, I don't have a view, really any kind of an expert view about whether masks are good, bad, or otherwise. But people need to be experimenting with solutions. And I think that it makes really good sense for store owners to be, and business owners, to have the kind of obligation, in a sense, to come up with those solutions by just allowing property rights and other rights to function. That's how American society is supposed to function.
Thanks, Stephen. That was that question was from George. So thank you, George, for that question. This will be the last question of the afternoon, and it's from Steve Hanley, and that is whether PLF is planning to support the rent registry lawsuit underway in San Jose. Brian, can you answer that?
Yeah, I was just looking into that, and thank you for bringing that to our attention. This is something that most definitely we will be looking at an opportunity to get involved. For those who aren't aware, San Jose adopted a regulation that requires all residential landlords to submit ridiculously intrusive information to a city registry, which will then be searchable by public records request that goes into individual data on each tenant, their name, how long they lived, what their rent was, whether there were any rent increases, the reasons for their departure from the apartment. This law has been attacked by both landlords and tenants, and even the ACLU has jumped in, and it appears very clearly, it appears to violate or at least threaten the US Supreme Court's decision in Patel v. City of Los Angeles, where the court held that the Fourth Amendment forbade Los Angeles from requiring hoteliers and from collecting, maintaining records of people who rent rooms and then having to turn it over to police upon request without a warrant. So yes, it looks like this case is currently pending at the Ninth Circuit, and as soon as there is an opportune moment, we will be looking to comment on this.
Thanks, Brian. And I want to thank all of you for joining us today for our inaugural town hall to talk about how we will rebuild America with freedom. I also want to express my appreciation for your support of our work. We always believe that our successes are your successes. So thank you all for joining us. Stay well, and we'll see you soon. Thanks so much.